May it please the court, my name is Woolf, initial B, and I appear on behalf of the accused, who is a child and may be identified as D.S. My client, a 14-year-old Indigenous boy, has been formally charged with burglary and stealing. My client has pleaded not guilty. The prosecution is relying wholly upon admissions made by my client in an interview performed after his arrest. However, it is my submission that these admissions may be excluded from the trial on the basis that the evidence is inadmissible as a matter of the law and under the statutory provisions of Section 130 of the Evidence Act 1977. My first submission is that there was an absence, or more so a blatant disregard, of the necessary consideration for my client's age and cultural background displayed by the police officers conducting the interview. The Christie rule states that it would be unjust to admit evidence of character gravely prejudicial to the accused, even though there may be some tenuous ground for holding it technically admissible. In such a case, the judge may intimate with the prosecution that the evidence, although admissible, should not be pressed because its evidence would be out of proportion to its true evidential value. In the Crown and Hasler case, prejudicial is interpreted as when the jury are unlikely to give the evidence more weight than it deserves, or due to the nature of the content of the evidence. The prosecution has based a burglary case on admissions made by a 14-year-old Torres Strait boy that did not fully understand the gravity of the situation he was in. It is entirely reasonable to assume that Darren has made these admissions due to the power imbalance, thinking that he had to agree with what the officers were saying in order to get out of the situation. My client's Indigenous and remote upbringing were not at all considered by police officers. These cultural barriers are clearly shown when my client has answered questions with nods or silence while avoiding eye contact and showing discomfort, as it is evident in the transcript and recording. My client has also answered questions on several occasions with what he thought the officers wanted to hear due to the interrogative and intimidating nature of the questioning, showing gratuitous concurrence. While these can all be considered as signs of guilt in some cases, they are more likely to be caused as a result of my client's cultural mannerisms and upbringing, and a lack of understanding of the situation. The Christie discretion is to exclude admissible evidence if the jury is likely to give the evidence more weight than it deserves, and would therefore be prejudicial to a fair trial. An admission of guilt is highly prejudicial, and due to the severity of these admissions, vastly outweighs the actual value of my client's admissions. The defence admits that the fairness discretion be applied to exclude this evidence as a result of lack of consideration shown by officers for my client's age and cultural background. For my second submission, public policy should apply for the discretion established in the Bunning Cross. This states that evidence produced by unlawful conduct should be excluded, outlining the threat of a disregard of the law by those that are authorised to enforce it. A 14-year-old Indigenous boy would fall under the definition of a special witness, as he is under 16 years old and likely to be disadvantaged as a witness. Under Section 420 of the Police Powers Act, an Indigenous person may speak to a support person in private. However, a person that Darren has never met cannot be considered an appropriate support person. Police officers in this case have breached several statutory provisions and shown a disregard for the law, therefore giving reasonable grounds to have this evidence excluded. Section 420 of the Police Powers and Responsibility Act also states that a police officer must inform legal aid as soon as possible that they have an Indigenous person in their custody. However, legal aid was not informed of this immediately. As Section 7 of the Police Powers and Responsibility Act states that it is Parliament's intention that officers strictly adhere to the law when exercising power, this brings us back to the Bunnings and Cross case, in which there are 5 factors that are impacted on whether this discretion was to be exercised. The first factor is whether the unlawful conduct resulted from a general mistake or was a deliberate breach of the law. It is unlikely that this was a genuine mistake, rather that these actions were a deliberate breach of the law, which were taken to deprive my client of any opportunity to properly prepare himself for this interview. The second factor involves considering the cogency and perishable nature of the evidence. Admissions would be considered cogent, however there is no perishable nature to a spoken admission from the accused. Factor 3 regards evidence being obtained in a pressing circumstance, which is not the case, as there are no pressing circumstances that would justify this breach of law from the officers. The only pressing matter for these officers would be that of them forcing an admission from my client before legal aid are able to be notified of his arrest. The fourth factor considered is the gravity of the charge, which is only burglary, not the most serious of crimes. The fifth factor considers that if breaching the law obtained the necessary evidence, what was the purpose of this law in the first place? Put simply, these provisions were put into place to prevent this exact conduct to be carried out in relation to my client and others like him, where the result has been that admissions have been made with the severity of them unbeknownst to my client. The actions by the officers have been conducted with full knowledge of what they were doing and how the breach of the law would impact upon my client's mental state and ability to prepare for an interview with grave consequences. It is for this reason that the defence admits that discretionary consideration be applied to this interview recording to ensure a fair trial. This concludes the defence's submission, Your Honour. Thank you.